Have you ever seen an accident where it feels like a dozen things went wrong at once, and you just think, wow, who is actually to blame here? Well, it's a simple question, but the legal answer is surprisingly complex. Today, we're going to dig into the fascinating story of how the law had to evolve to handle exactly these kinds of messy, real-world situations. All right, let's get right to the heart of it. Imagine a car crash. One driver was speeding, sure, but the other one completely blew through a stop sign. So who's at fault? Is it 50-50? Is it one or the other? This is the exact kind of headache the legal system has been dealing with for years. And how they figured it out? Well, it was a total game changer for legal thinking. So, here's how we're going to break this all down. We'll start with the old school rule, the but-for test. Then we'll see exactly where it starts to fall apart. After that, we'll get into the landmark case that brought in a common sense approach, lay out the new rule, and finally, talk about why this whole shift is so important for getting justice in the real world. Okay, so let's start at the beginning. The traditional way to figure out who's to blame in a negligence case was this seemingly logical, pretty simple rule called the but-for test. The whole test boils down to this one question. Would the bad thing have happened but for what the defendant did wrong, if it weren't for their negligent action? If the answer is no, then boom. Legally, their action is the cause. Seems pretty straightforward, right? Almost too simple. And here's how it actually works. First, you pinpoint the negligent act. Let's say it's someone running a red light. Step 2, you mentally erase that from the timeline. Then you ask, in this new imaginary world, does the accident still happen? If the answer is no, then you've got your cause. It's a very clean, almost scientific way to find the one thing to blame. Yeah, but as we all know, life is almost never that clean and simple. And this is where our story gets really interesting, because this one-size-fits-all rule just completely falls apart when it slams into the messiness of reality. Look, the but-for test is fine for simple stuff. One car hits another, easy. But what happens in a complex situation where you've got 2, maybe 3 or more different screw-ups from different people all mixing together to cause one big mess? That's when this old rule can give you some really weird and frankly unfair results. And hey, don't just take my word for it. This isn't some academic theory. The High Court of Australia, we're talking the highest court in the land, came right out and said it. They recognized that the classic but-for test is often, and I quote, inadequate when you've got multiple causes. That was a huge deal. It was basically the court admitting the old way just wasn't cutting it anymore. So that admission really paved the way for a game-changing moment, a landmark case that would totally rewrite how the law thinks about blame. It was time for a big common sense update. And that case was March versus Stramar, back in 1991. So here's what went down. A truck was parked, negligently, right in the middle of the road in the dark. Then a drunk driver comes along and smashes right into it. Now, with the old but-for test, you could argue that but for the drunk driving, the crash wouldn't have happened. But the High Court stepped back and said, hold on, that's just too simple. Instead, they brought in a more flexible, common-sense way of looking at it. And what this really shows is a massive change in thinking. The court was basically saying, look, justice can't always be a simple plug-and-play formula. Sometimes you've got to look at all the pieces on the board and just use your common sense to figure out what really caused the problem. So what did this new, smarter, more adaptable rule actually look like? Let's unpack the mechanics of this whole common sense approach. The absolute key to this new rule is the idea of a material cause. This is a biggie. Instead of hunting for the one and only cause, the law now looks for any action that was a significant contributing factor. It's a much more realistic way to think about how things happen in the real world. So here are the new rules of the game. Someone can be held responsible if their mistake was a material cause, even if the person who got hurt also did something wrong, and even if some other third party was involved too. Basically, the blame can be shared. The only real way out is if there's a huge policy reason to say their action was just so disconnected from the final harm that the chain of causation was broken. Okay, so we've waded through some legal theory, but why does any of this actually matter to us? Let's bring it all back down to earth. What happened here is that we moved from a really rigid, low flexibility test that was obsessed with finding one single cause to a much more flexible test that actually gets that there can be multiple material causes. It's a shift from seeing the world in black and white to finally seeing all the shades of gray. And this wasn't just some minor legal tweak. This shift allows our entire legal system to hand out justice that feels way more fair and logical. Why? Because it finally acknowledges that accidents are often a chain reaction, not just one person's single mistake. It really makes the law more, well, human. In that year, 1991, that's the moment it became official. The moment the High Court fully embraced this smarter, more sensible way of deciding who's at fault. A true win for common sense in the courtroom. But this whole thing leaves us with one last, really interesting question to chew on. We're celebrating this big shift to a common sense approach. But whose common sense are we talking about? Is a more flexible rule always a fairer one? Or does it just open the door for more personal opinions? It's a great reminder that even in the world of law, the hunt for perfect justice never really ends.